expect the UK to be included in this, would caution the court against being used as a political tool, would caution the court that this sort of mechanism, an advisory opinion, is not an appropriate forum through which to air these very complex, politically fractious issues that are in nature bilateral, because Israel isn't partaking of these proceedings, and its rights and interests are inevitably deeply affected by what is going to be discussed. It's totally inappropriate to have a mechanism that is supposed to simply provide advice as to the law and to use it in such a targeted fashion against the Jewish state. That and a host of other procedural issues that I'm sure they will be picking up on. I'd be quite surprised if even those states that seek to make a positive contribution on Israel's behalf delve into the substantive elements of what is being alleged against Israel, because it is so vast and the historical misrepresentations are so enormous that I think many states will probably want to stay well away from that and focus on the technical legal issues and the problems that that arise from the court being asked to consider what is really an inappropriate use of the International Court of Justice.
And just going on to that, and notwithstanding the loaded questions that are being asked of the court, prejudging a lot of things. What if it goes against Israel? I expect it to. It's an international forum. What are the worst consequences? For Israel, are they political? Are they legal? Or is it really a dead letter on the basis that what can happen with vetoes and so on in the Security Council?
So there are a couple of things to bear in mind here. The first is I mentioned that the advisory opinion itself, the Corporates Act, is not legally binding, but it is intended to serve as a basis for further attacks against Israel. And so that's number one. The second purpose that is sought, I think, through these sets of proceedings is to give a judicial stamp of approval onto tens of thousands, if not hundreds of thousands of pages of UN reports that accuse Israel of the worst possible horrific crimes that have been generated over a substantial amount of time by armies of NGOs, by UN special rapporteurs, and by UN bodies that make outlandish and untrue allegations against Israel. But this faux evidence being put before the court, if it is considered and if it is given that stamp of judicial authority by the International Court of Justice, it will then inevitably be deployed against Israel in other fora, including in probably domestic courts, and critically in another international court, which we've yet to mention, which is the International Criminal Court, which also sits in The Hague. Now, unlike the International Court of Justice, which deals with states and disputes between states, and questions of international law that impact states, the International Criminal Court deals with individual criminal responsibility. And there's separately an investigation against Israel that has been now, I'm going to say, Karim Khan, the current prosecutor, has doubled down on this investigation. It actually began under a previous prosecutor, Fatou Bensouda, but it didn't seem to have gone very far. At least there wasn't an awful lot of publicity around it until shortly after the 7th of October, where what has happened has sparked Karim Khan on to visit the region a number of times and to make various unsettling statements. The key thing to know about the International Criminal Court is that it doesn't have jurisdiction over Israel, over the territory. The ICC works on the basis of what's called the Rome Statute. This is the governing statute, and it requires countries to sign up to the court. This is how most of international law works. States have to agree to be bound by the vast majority of international law, and they do that through treaties or conventions. There is another subset of international law, customary international law, which can bind states even if they're not signed up to it. But that often deals with general principles and practice that has developed over a long time, and it is usually not particularly controversial. So Israel never signed up to the Rome Statute. Neither, for that matter, did the United States. Both of those countries had been involved in the negotiations and the drafting of the Rome Statute and the initiative for there to be an international criminal court. And then towards the end of that process, it started to become clear that this was going to be used as a political tool against Israel. And in particular, that was clear from one of the definitions of war crimes, which involves the transfer of populations. The words directly or indirectly were inserted into the definition of the Rome Statute, and that was seen as a real indication that the ICC was going to accuse Israel of committing crimes on the basis that Jews were living in Judea and Samaria. So I see that as the primary reason that neither Israel nor the United States ultimately signed on to the ICC Rome Statute. But that gives the court jurisdiction over the territory of the state signatories. And Israel has been adamant from the outset of the ICC's interest in the Jewish state that it simply doesn't have jurisdiction. And we'll have to see ultimately what happens. That the question of jurisdiction isn't completely shut. There's going to be more argumentation, I'm sure, on that if these proceedings go forward. But it's important just to understand and bear in mind how this whole system of lawfare against Israel is inextricably linked. All of these international legal institutions are being used in a circular fashion. You know, the UN bodies, the ICJ, the ICC, they're generating this documentation and giving each other legitimacy, and then seeking to actually execute legal consequences. And in the case of the ICC, that would be in the form of arrest warrants against Israelis around the world.
Yeah, I was going to go on to that. I mean, the end game for that is an Israeli in a country signing up to the ICC, the UK, France, wherever, they would be at risk of an arrest warrant if they come to this country and being taken to the dock of the ICC, putting it in the most blunt terms. I think we saw it here. I think maybe 15 odd years ago.
I have a story about that.
There were arrest warrants being given by district judges at Westminster magistrates courts until I think the Parliament intervened for Israeli nationals who'd have the temerity to land in our country.
So I attended on one of those occasions. I was a law student, and I saw in Yediot Ahronot, Ynet, that there was an arrest warrant being sought against Ehud Barak, who was due to be landing in London Heathrow later on that evening. And it was due to be heard at Westminster Magistrates Court, which used to be on Horseferry Road, but it's another casualty of courts being closed up and down the country. So I rocked up thinking that everything would be long finished, and I found a small gaggle of press who were waiting. And we ended up waiting there all day because the resident judge for whom this application had been intended, I think it was anticipated that there would be some sympathy in terms of making the application. Resident judge was on holiday at the time, and so it had fallen to his deputy, and his deputy, I thought, plainly didn't want anything to do with this. And the rest of the day passed, I think, where there was advice being taken from the Foreign Office, and you're absolutely right that ultimately the government stepped in to stop this practice. But it was very interesting because I went up and I spoke to the lawyers who were applying for this warrant after it had been denied. And I asked, I was quite precocious as a law student, I asked if they intended to harass every Israeli official that wanted to make a journey to London, to the UK. And the response that I had was unequivocal. Yes, absolutely. This is essentially what they were there for. So there was no embarrassment even that this process was being used to harass Israeli officials. And it takes me back to an op-ed that I remember from 2011. I mean, lawfare has been going long before that as well. But in 2011, Mahmoud Abbas, who's currently, I think, entering his 19th year of his four-year term of office, Mahmoud Abbas in 2011 wrote in the New York Times calling for the internationalization of the conflict as a legal, not just a political matter. And this was about a campaign for the state of Palestine to join the United Nations and to use UN bodies and international legal fora to attack Israel through lawfare because military means had failed. That was Mahmoud Abbas's declaration of lawfare. And the example that you've just used from probably 15 years ago.
2011,
was one manifestation of that. And the real concern, I think, which we ought to have is that as a result of what we're now witnessing at the ICJ and the ICC, we may likely see repeats of that.
Yeah, because there's now a filtering mechanism of the Attorney General, I think, or the DPP's leave being required before you can bring the arrest warrants. Of course, that's all good in theory, but if Jeremy Corbyn's DPP or AG was in charge, who knows what would happen. But I just want to go on to the South Africa case, if I can. Obviously, that's a very preliminary and provisional stage. Are there consequences at the moment in relation to, I think, Israel having to produce reports for the International Court of Justice? I mean, what are the obviously this hasn't got to the merit stage. We're at a very, very, very short stage in relation to that. But can you just explain what the consequences at the moment of that are? I think there's got to be reports produced and so forth.
Certainly, yes. And in the next couple of weeks, I think it's due. Just to give you a little bit of background, the hearing that you've all heard about in the South Africa-Israel case happened very quickly. Very unusual. Most cases take a number of years to come before the court, certainly for the substantive hearing. But this was an emergency procedure because South Africa was asking for what's called provisional measures. And I mentioned that its main, in neon lights, request was for Israel to cease its military operation in the Gaza Strip, and it didn't succeed in obtaining that. But when the court assesses provisional measures, it doesn't make any assessment on the substantive merits of the case. And in fact, when you read the order that the court gave, I think it's 25 odd pages. And I really would recommend, if you're interested, please go onto the ICJ website and have a look at it, because it's really telling that all of the reporting that I was witnessing in the aftermath of this ruling didn't actually state what the court had found and what it had ruled. And immediately you were hearing that Israel had been either found guilty of genocide, or that there was a plausible case that it had committed genocide, or that it was in breach of the Genocide Convention. And all of that was just utterly false. What the court considered was whether the case that South Africa was bringing was plausible. Now, plausibility has never properly been defined at the International Court of Justice, and the court actually goes through a series of footnotes of 15 previous cases where plausibility in this context or similar context has been used. But essentially, when you read what the court concluded, I think there's only one conclusion that you can be left with as to what the court decided was plausible. And it decided that the case that South Africa brought plausibly fell under the Genocide Convention. It didn't go further than that. It didn't assess Israel's response, even though Israel spent a day making submissions and talking about the measures that it takes to protect civilians in the Gaza Strip, the humanitarian efforts. None of that was considered. And when you compare it to other cases in which there's been potentially a more substantive finding on plausibility, it's instructive to note that the court actually had before it very detailed reports which it referenced and considered when it was dealing with the provisional measure stage. None of that happened here. So it's almost tautologous that the court has decided it's plausible that the case South Africa brings falls under the Genocide Convention when you think about the fact that South Africa has brought the case under the Genocide Convention. And I had it explained to me. It was very, very interesting. He's not the only one. There were a number of people who were extremely senior members of the judiciary who have considered this to be a coup, a real achievement on the part of the former president of the court, Donoghue, the US justice. There's just been a change, and now it's a Lebanese justice who's president of the court. That she had crafted a document that so many of the judges were able to sign up to. And I found that extraordinary because that is not, at least how lawyers normally think a court of law works. If you look at the dissenting opinion of the Ugandan judge, Sebunito, she sets out very clearly, extremely cogently, what the law is and how to apply it. And the court didn't do that. Instead, it sounded like it was an effort to get a UN resolution passed, to get as many people to sign on to something as toothless as possible so that they couldn't object to it. And that, to me, you asked about the consequences for Israel, Julian.
Yeah.
And I'm sure we'll spend the majority of this evening talking about that in detail. But to me, that spells out desperately dire consequences for everyone, for anyone who prizes the rule of law, for countries that are law-abiding, for those that value the international legal order and the International Court of Justice. Because if it allows itself to be used as a political tool in this fashion, that spells bad news for everyone. And it's worth remembering that in the spring of last year, Iran rejoined the compulsory jurisdiction of the court. That's very interesting.
Well, there's some jurists from wonderful rule of law countries like China, Russia, Somalia, well known for their wonderful rule of law cultures who are on that court. So I'm sure that there'll be a fairer trial there than at Lavendale Magistrates Court in the future. But I just want to ask you about that. As I understand it, Germany will be intervening. Obviously, irony has died a death. Germany will be intervening on behalf, I think, of Israel at the ICJ. Is that right in the future? Or I've said there'll be in future proceedings there. So
I'll be clear, this is about the South Africa application. Germany actually very early on said that it would be intervening on Israel's behalf before the provisional measures had even been granted, which I thought was interesting and an indication to the court that it wasn't pleased at all with the fact that the court was potentially being so politicized. We've had public statements from the United States that this is a meritless case, and also Prime Minister Rishi Sunak indicated that it was, I don't want to misquote him, but it was something along the lines of it was terribly wrong and it didn't serve the interests of the court of peace. So we've had political statements, to be sure, from Israel's allies calling out the danger, but Germany rose above that even to make it clear that it would be advancing a substantive application on Israel's behalf.
What I'll do now is we've got a microphone. Thank you very much indeed. I know you all have questions for Natasha, so let's take a few questions if someone can start. And remember, whenever you moderate Jewish talk, a question always starts with what, when, why, who, how. Not lengthy statements. But let's take a question from someone. Yep, over there. Thanks. Yeah.
Explain the position of it, because when you said that the current advisory sort of takes for granted help us understand or that's how they control the policy and verify. And I know this is a or I had, whether this I've never understood the sort of I don't quite understand the position that Israel or its attractive state. So could you just explain that?
With pleasure. There's a lot to unpack there. And I probably need to caveat it with, I don't speak on behalf of the state of Israel. And so my analysis might not necessarily be advocated, but I'll also come on to why I think that might be the case. So your question essentially, and NIAC and IAC, international armed conflict, non-international armed conflict, is very relevant when we come to look at what's happening in Gaza since Israel's withdrawal in 2005. But if we're going to talk about, this concept of occupation and what that means, and whether it's actually valid as a legal term, or as I would suggest, a political term, which fits into Abbas's declaration of lawfare very neatly. To be able to assess that, we need to go to the beginning and work out what the starting point in international law is of the status of the territory of Israel. And I mentioned customary international law as opposed to treaties in one of the responses earlier. Custom is a strange beast. It develops over time out of what's called state practice. And it arises when states behave in a certain way, believing themselves to be legally bound to behave in that way, that develops a customary law or rule or norm, which then ultimately becomes binding on states. And there is a critical rule of customary international law that defines a country's borders when it comes into being. That rule is called uti possidetis iuris. It's universally applied. Anywhere that there is a new state that comes into existence, the default, so where there is no other agreement to the contrary, uti possidetis iuris, tells you what the borders are. And it does so by reference to the pre-existing administrative lines of whatever unit came before it. Case in point, we all agree, the international community is aligned, that Russia occupied Crimea from Ukraine. Why? Because of uti possidetis iuris. Because when Ukraine came into being, the administrative lines meant that Crimea was part of sovereign Ukraine. Think about, I'll come on to Israel in just a minute, but just to as a thought experiment in a parallel environment, if Ukraine were to recover Crimea from Russia in the current war, would anyone accuse Ukraine of occupying Crimea? Of course not. You cannot occupy what was originally your own sovereign territory. Bear that in mind when we come to assess Israel, because one thing we do as lawyers, if you present me with a problem, or question, I will look to precedent. I will look at what happens everywhere around the world, and I will use that to be able to explain to you what the outcome or what the position should be in your case. Not when it comes to Israel, unfortunately. So what was the position in 1948? When Israel declared independence, it was the only state to emerge when Ben-Gurion made that declaration. Now, the Declaration of Independence, interestingly, doesn't mention borders at all. It refers to Eretz Israel, the land of Israel. And there are various scholastic discussions as to why that was. Ultimately, it was a time of great confusion. There had been the partition resolution by the United Nations, which proposed a division of the land, but that was never accepted. And it was never implemented. And so far as legally binding instruments of international law are concerned, it was a General Assembly resolution, which has no legal status. It was simply a political recommendation that was never adopted. So Israel declares independence, and immediately it's attacked by its neighbors, and it's the War of Independence from 48 to 49. According to uti possidetis iuris, Israel automatically inherited the pre-existing lines of the British Mandate. And on the eastern side, that ran all the way down the Jordan River to the Red Sea, including East Jerusalem and the West Bank. And of course, it also included the Gaza Strip. That was the starting point. None of what I'm saying is in any way advocating for what the end position should be, or what we can come on to talk about possible solutions. These are inevitably going to be political rather than legal. But if you're going to use a term like occupation, you need to be clear about what the legal starting point is. So Israel inherits those pre-existing lines, and Jordan occupies the West Bank and East Jerusalem from 48, 49 to 67, and likewise Egypt vis-a-vis Gaza. And then Israel in 1967 recovers that territory. Now, in the West Bank, it instituted a temporary administration. Why, you may ask? If this is Israeli sovereign territory, why? Well, Israel applied its law administration and jurisdiction in full to East Jerusalem. It reunited the city. But in the West Bank, there was an expectation on the land for peace formula that in order to make peace with Jordan, there would have to be something given to the Jordanians, some slither or piece or chunk of the West Bank. And so that was kept in a temporary administrative framework, one which has lasted over 50 years. But that was, I think, the reasoning behind it. And Abba Eban was very clear in 67 in a report to the UN Secretary General that Israel's application of law, administration and jurisdiction in full to Jerusalem was not annexation. He refuted the use of that term. And my suggestion would be you cannot annex what is already your own sovereign territory. So where does that leave us? Well, I think the term occupation in respect of this is utterly misguided, but it has gained currency and it is taken as a given. It is now the occupied Palestinian territory. Even the British government refers to it as the OPT. But that is a political term of art. The other aspect of the term of occupation in international law, it's really important to know, nowhere else is there ever been a concept of illegal occupation. This is, again, unique to Israel. Again, something I would suggest is a political rather than a legal term. So that's the starting point. Where we go from there, ultimately, will have to come down to negotiations. But if we look at what the situation is since the Oslo Accords, I think, again, even a politicized term of art, occupation, is deeply, deeply misleading. Because after Oslo, the Palestinians had an autonomy in the West Bank, and they still do. I mentioned Abbas was entering the 19th year of his 4-year term. We would all prefer it if there were more regular elections and more democratic accountability and less corruption and less torture of political opponents. Absolutely. Unfortunately, that is likely to take a great deal of time before we can get to the point where Palestinian society can be run in that fashion. But there is a Palestinian autonomy. There is self-determination. And Israel does not control areas A and B of the West Bank. And people quite frequently forget that. And since 2005, of course, Israel doesn't control the Gaza Strip. That was a unilateral withdrawal. And it facilitated, first of all, the election and then the violent takeover by Hamas and the formation of a terror enclave in the Gaza Strip. And we've all seen the consequences of that over the last few months. Again, the term occupation is utterly misplaced. I don't think that there are many international lawyers or military experts that actually, realistic ones, ones without an agenda that advocate the term occupation to Israel in Gaza pre the 6th of October. People say it, but it's a nonsense. It's a development of international law that they're trying to advance on the basis of supposed control over borders, which factually is inaccurate because we all know that Egypt's control over its border is far more substantial than Israel's, and on the basis that there's been a blockade which, interestingly, even the United Nations has recognized as lawful. So that's a little bit of the background and the history. As ever, it's never straightforward. And that's why the sound bites and the misrepresentations and the politicized slogans are so successful in hoodwinking the public. And certainly I would suggest that they've even done so with, with respect to the terminology and the policies now being aired by the Foreign Office and Her Majesty's government.
Let's have a couple of questions. I know everyone's got questions, so let's have 2 questions. You at the back, sir, please. If you want to just shout out, I'm going to repeat it to Natasha. We've had a problem with the microphone. Do they? Yeah, or come up here and ask it. You want to come up here and ask it? Just ask your question, sir. Go on. Okay, I'll repeat it. Yeah. Go on. Ask your question, sir. That's right.
Our current Foreign Secretary trying to make a unilateral declaration. Well, due to future Prime Minister today speaking again about these questions in terms of immediacy ceasefire in the Palestinian state. And it seems to be that if the impulse are accurate, that there will be a change in government. So my question is this: what do you expect to happen in terms of a change in policy of the British government once the general elections happened? And what do you think Israel's response to that would be?
Okay, I'm going to go on to answer that now. Okay, so a unilateral declaration and a change of government in this country, Natasha.
Well, I know far better to make political prophecies, but I will be very happy to answer the second part of that and also talk a little bit about why I think this is so damaging. Israel's cabinet today issued a declaration in response to this sort of mantra and to this bizarre phenomenon that has arisen after the 7th of October, that the Palestinians, in particular Hamas, ought to be rewarded for the atrocities that they committed, with a Palestinian state being made a priority. So that response from the cabinet was to reject it outright. And it is an upending entirely of all previous international policy, which has seen the only resolution possible through a negotiated solution. And it is deeply, deeply concerning that this new position that is developed, which is inexplicable, is essentially indicating to any Palestinian leader that dialogue is worthless, and that, in fact, all they need to achieve their ultimate aim is violence. And that's pretty concerning when you think about what the ultimate aim is, because Hamas are clear about it, but the Palestinian Authority have been clear about it also. You know, a Palestinian state is there to serve as a platform for the continued efforts to eradicate the state of Israel. So shocking and deeply, deeply abhorrent that we are in this position. And I think, you know, your question as to a prophecy is probably underlined by your own expectations of where things will go after the next election. But if Keir Starmer's prior position, which is that Hamas needs to be eradicated, is credible, then it is completely at odds with what he's most recently articulated. And if the Labour Party, they become the next government, really care about ordinary Palestinian citizens who have been utterly abused by their leadership, and this is the so-called moderates, the Palestinian Authority, as well as Hamas and Palestinian Islamic Jihad, and used as political pawns by the likes of Iran and Qatar, if they actually cared about the ordinary Palestinians, then they would also make getting rid of Hamas a priority. And the idea that you would set up a state with all of the power to conduct the 7th of October over and over again is very, very difficult to follow. And the most recent remarks, especially at the Munich Security Conference over the weekend, are extremely difficult to understand in that context. The two-state solution has always been a wonderful, utopic hope and desire. When I visited Ramallah, what gave me the most cause for hope was visiting venture capital startup funds looking to create Silicon Valley in the Palestinian Authority, looking to create a Palestinian middle class with a stake in society, ones that can engage in a political system and hold their leadership to account. And that takes time. The minute that you create a framework where you can snap your fingers and decide that there's going to be a handshake in the Rose Garden of the White House and everything will be over, what you are doing is perpetuating the conflict and pushing peace further away. And there's one other thought I'll leave, which I remember extremely well in the context of the prior Obama administration and the deeply misguided, I think, policy that Obama was espousing on settlements, a moratorium of settlements that he was demanding at the time. Mahmoud Abbas, in response to that, said, "How can I be less Palestinian than the President of the United States?" Now, what did he mean by that? He couldn't go to the negotiating table asking for anything less than Obama was asking for on his behalf. He could far less leave that table having achieved anything less than the Americans were demanding on his behalf. And this consistent policy by the international community to project what the solution should be and to make demands on behalf of the Palestinian people, which they're not even making. Abbas doesn't want a state. Of course, he wants to go and be the statesman and speak at the United Nations and criticize Israel, but he doesn't want the responsibility of running a state, of taking out the garbage, of actually running schools, instead of promoting and indoctrinating hatred from kindergarten level up, instead of paying the salaries of terrorists, as he did. No matter what banner they coalesce under, the organizers and the orchestrators of the 7th of October attacks on Israel, who were released in the Gilad Shalit deal, still had their salaries paid on a monthly basis by the so-called moderates in the Palestinian Authority. So let that sink in.
To slay, I think they call it.
Yeah.
Paid for by our tax. Some of our tax money is used.
Enshrined in Palestinian law. So I mean, all of these answers, I'm sorry, have been extremely detailed and long, but that just gives you a flavor of some of what these individuals making these statements are wading into, and I think blind to the facts on the ground and the issues and the history. And that's deeply concerning because they for sure need to be receiving better advice.
Let's take a couple more questions together. You, sir, and then you, sir. Yes. Go on, sir.
UN found X, Y, Z. This then stimulates further street protests, etc., etc. Is there's no doubt that Israel has an incredible amount of just right on its side, but it seems to me that there's no real possibility of it getting traction in any international court or any international forum. What is the best way forward? How, of course, you know what's going on. Most of us in this room have a sense of history, so we know some of the background, if not all. But how is this potentially going to be projected to prevent what's going on every Saturday in London, to prevent what's going on in many cities, and to prevent the constant Twitter feeds that go out on a daily basis to useful idiots that just make mischief on an ongoing basis, and the continuing I don't know what's the way that Israel's supposed to be talked out of existence, which is what seems to be happening.
Thank you. I'm supposed to summarize the questions, but I'm too scared to summarize that question. And you over there, please, sir. Yeah, it's
So the line he was talking about.
Yeah.
What is your response to that in terms of putting your thoughts on the breakdown of the sort of numbers, and why is there no from the Jewish perspective?
That has been from me. Yeah. Okay.
Natasha?
So I'll take numbers of casualties first. You're absolutely right when you say, the Palestinian Health Authority, which is Hamas. It's extraordinary that the figures put out by a internationally prescribed terrorist organization are being reported without qualification. And then, when the BBC, I'm conscious of the fact that we have some representatives in the audience, but when the BBC was ultimately being called out on that, the response was simply to report the same numbers and include Hamas-controlled Palestinian Health Ministry. But that doesn't really give the proper context, I think, to the viewership to understand what to do with this number. And we've seen the impact of that because it's being quoted by politicians and in reports and by humanitarian organizations. So there are a couple of problems with this number. First of all, it is undeniably, it's lacking in credibility. Let me put it that way. One example of this was on the 17th of October, when the BBC and others were reporting that there had been an Israeli airstrike on the Al-Ahli hospital. And immediately, within a very short time of this being reported, the announcement was 500 casualties as a result of this strike. Well, it was later utterly discredited. It was a Palestinian Islamic Jihad rocket that fell short in the hospital car park. But that 500 casualty figure was never revised. And to this day, you still have a sizable jump on the 17th of October. That's incorporated. Now, that's one instance that we know about. So actually verifying these figures is impossible to do. That's point number one. The added problem here is that they are put out as a wholesale figure, with no distinction between combatants and non-combatants. Now, Israel has been clear, it has killed, it knows it has killed over 9,000 Hamas or other Palestinian terrorists And it has done so, it's careful about putting these figures out, and it has to verify and be clear that it has the evidence to support it, but that is its current estimate. So that's point number 2. Point number 3 is we have no idea how these deaths are said to have occurred. Now, we know from the Al-Ahli hospital that was caused by a Palestinian Islamic Jihad rocket that fell short. Hamas rockets fall short on a regular basis. These aren't precision strikes with warnings and with people calling them off if there are too many civilians in the vicinity when Israel conducts strikes. These rockets, Palestinian rockets fired out of the Gaza Strip aiming towards Israel that fall short, they fall short, killing indiscriminately. So how many Palestinian civilians have been killed in that fashion, and how many of them have been shot and bombed by Hamas directly? Because we've seen reports of fleeing civilians being targeted by Hamas, executed by Hamas, because they're so desperate to dissuade people from leaving their areas of terror infrastructure and keeping their own human shields. So all of that critical context is completely absent when you keep hearing these thousands of figures parroted over and over again. That is not to say there haven't been civilian casualties. And every civilian casualty is an absolute tragedy. And every civilian casualty is absolutely the responsibility of Hamas that started the war on the 7th of October, that have conducted it in this fashion, that are using human shields, and that are seeking through their conduct of this war, their aim after the 7th of October, and we saw what their aims were on the 7th, and they were clear about that. After the 7th of October, they don't have a hope at this juncture of defeating Israel simply militarily. Their only hope is international pressure. And they garner and gather that international pressure on the basis of inflated casualty figures and on the basis of presenting those Palestinian civilians that they have murdered as a result of Israeli military action. Now, that's all really important background before we step back and look at the figures. Because even on these inflated and unattributed figures that Hamas are putting out, if you compare them against the casualty figures that Israel has put out for the Hamas combatants, over 9,000 now, you get a ratio of 1.6 civilians to every 1 combatant. Now, that sounds bad, but in the context of urban armed conflict, the UN figures for the global armed conflict are between 9-1 and 8-1. For the US, in Afghanistan and Iraq, the casualty ratios were between 3-1 and 5-1. 1.6-1. In an urban conflict environment against an enemy that is seeking to drive up the civilian casualty count as much as it possibly can is absolutely unheard of. It is unprecedented. It is testament to the unprecedented measures that Israel is taking to prevent civilian casualties by issuing warnings, by creating humanitarian corridors, by phone calls to individual householders, leaflets that it drops, text messages, calling off strikes, targeted strikes, and seeking, in the context of the terror tunnels, not blowing those up, seeking to flood them instead, to take out the threat that Hamas is posing from under civilian neighborhoods. So that's important context that never gets aired. That difference between the measures, the standard that Israel applies and abides by, which is actually far in excess of what international humanitarian law requires, and how that compares to other armies and other armed conflicts. The US has recognized on a number of occasions and said that, in a similar position, the United States probably wouldn't be able to do quite as much as Israel is doing. And you do even get that acknowledgement, reluctantly, perhaps, from spokespeople, in particular, I think the National Security Council spokesman, John Kirby, indicated as much. But clearly it doesn't fit the narrative.
Let's take a couple more. Sorry, yes. Yes.
Why is that? But it's representing Jewish population on television, as opposed to what appears
I don't-
let's get a couple more questions.
Well,
and
we've
then
got
we
one
can-
question before we go on to
yeah.
that I haven't got to yet. Just I don't know if anyone timed my answer, but the answer might lie in that it takes time to be able to explain the facts and the reality. And that's just not something that broadcast media are interested in. They want the snippets, they want the headlines, print media, unfortunately, too. But you're absolutely right. And this brings me to the answer to the first question that was asked. What do? We can't give up. And that's not just because, the truth is on our side and we can't allow these blood libels to permeate. I think it's also, at least I see it as a duty to the truth more generally, and to international law more generally, and to the rule of law. So I think educating as much as possible, doing things like this, speaking as much as possible, engaging, challenging, pushing back, questioning, complaining. I'm told, I've yet to see it, but I'm told that, complaints to the BBC actually get read.
Really?
So those sorts of activities are really valuable. And we've seen small shifts. And, they even had me back for short periods. So that's critical. I recall many, many years ago hearing Alan Dershowitz talk about how his generation had dropped the ball. When people were accusing Israel of occupation, they didn't push back. And now it's become a given. And this has been the case across all of these blood libels: genocide, now ethnic cleansing, colonialism, war crimes, violations of self-determination. They have been able to take hold because there was no or not sufficient pushback. And I think things have changed in Israel, because it used to be that people in Israel said, well, we know what we're doing is lawful and right and moral. And we know none of this is true. We don't have anything to prove here. And I think the realization has suddenly or slowly sunk in that actually the misinformation and the way in which the international community is being weaponized, especially in terms of international discourse against Israel on the basis of these blood libels, is ultimately having an effect on Israel's ability to defend itself. Because people are talking about a timeline that Israel has been given for its self-defense in the Gaza Strip. Now, that's also completely incongruous, because the way that Israel is able to minimize civilian casualties is by going slowly and methodically and taking out Hamas terrorists house to house. And if the international community is putting a guillotine, you have this amount of time, and then you're no longer allowed to defend yourself anymore, and it is doing so on the basis of all of the blood libels and the misreporting and the misinformation, then I think increasingly in Israel there's a recognition that it has to fight back on the information war, and that it has to set the record straight. And all of you are in a position to contribute to that battle. And being here this evening is a key part of that process.
Let's get some more questions in at the back. Thanks.
From feeling like every morning it's flooding left, right, and center, everything's coming at me, from all sides on social media. Sometimes it just feels like we're such a small place and we need more partners, we need more people, we need to get more people on board. But even more than that, it feels like we're constantly, and I say we as the Israel on the defense. When are we going to do something? What is it that we're going to do to get in front of this? When are we going to be the ones speaking? What is it we're going to do so that it's not us saying, no, we're not committing genocide, no, we're not, but more of a Hamas, you are the war, Hamas, we're taking it to court. When are we going to do this?
Let's take a couple more questions. Yep. Over there, please, gentlemen there. Thanks. And one more question from someone. Yeah, over there in the front row. Yeah, thank you.
King got involved in the bloodline case, legitimized it, so it ended up in ballads, books, culture. And my question is this: is there a win there? Because in people's minds, they're thinking Israel, war crimes, genocide. So they make that link just by putting Israel in the result. So is there a win?
Okay, thanks. So 4 easy questions. Question 1 is on how does Israel go on the attack? Question 2, UNRWA and Hamas, and question 3/4 is on genocide and obviously this awful dichotomy that's used. Over to you. Repetition, deviation is punished.
I'll go backwards, and in fact, they're all linked in a way. In fact, but you're absolutely right. South Africa won because it didn't have a case. It doesn't have a case. It's meritless. But that's not what South Africa is about. It had a full day with, the international media hanging on its every word to advance every blood libel against Israel. And yes, genocide was the hook that it used to get this case to the ICJ. And that's a technical legal matter because Israel is a party to the Genocide Convention. And so the court has jurisdiction over this dispute that South Africa has claimed. But it included apartheid, ethnic cleansing, war crimes, breaches of international humanitarian law, everything which the court actually, would have been clear aren't relevant to the question of genocide, but they were part of the shopping list of accusations because South Africa was playing to the gallery. It was a propaganda exercise, and absolutely. I was on South African, kind of the version of the BBC. There were people saying, well, this is a massive success because now finally you can talk about Israel and genocide in the same sentence and it has credibility. And I was spot on. That's what this was about. And it is the modern blood libel. In the Middle Ages, the idea that Jews killed Christian children to use their blood in Jewish rituals was widely believed. Today, it's widely believed that Israel is targeting Palestinian children in exactly the same way. There is no truth to either of them. But this is the modern manifestation of it. And you're absolutely right that, in terms of the effect that the ICJ has already had, it doesn't matter what the verdict is, because the international community has said its piece, and you will see the effect of that vis-a-vis Rafah. This is an interesting point because South Africa made a further application to the ICJ to stop Israel from going into Rafah, and that was rejected. And we'll see what happens on the basis of the report. But it's no surprise that South Africa is going to keep coming back to the court and saying Israel's not complying with the provisional measures, because the provisional measures, other than the report, didn't actually create any new situation. It simply said Israel needs to comply with its international legal obligations, with its obligations under the Genocide Convention, which Israel has been consistently clear about the fact that it is complying with. So this, producing an order which didn't say anything and which made a series of provisional measures which the Ugandan judge called redundant because they didn't advance the position anymore, is setting up an awful lot of problems for, I think, South Africa to keep coming back to the court. The kicker on all of this, yes, it's about presenting Jews as the new Nazis, but it's also about weaponizing what has been done to the Jews. And that's not just in the Holocaust, that's also on the 7th of October, because what Hamas did on the 7th of October were acts of genocide, targeting Jews because they were Jews. Now, other non-Jews got caught up in this process. There were some Israeli Arabs, there were foreign workers, but the indoctrination, and I'll come on to UNRWA's role in this in a minute, from kindergarten level up is to kill Jews because they are Jews. And it's so interesting that when you hear interviews, bashing the BBC a lot tonight, but the BBC and others will translate what ordinary people have said as Israelis, but the word they use is Yahud. They're talking about the Jews constantly. So the idea here is that genocide is being completely inverted, and it is the real victims of genocide that are being accused of it. The question as to what the win is, I think, factors into some of the, well, the first question in particular. So I'll just deal with UNRWA briefly. Why can't a case be brought against Hamas? Why can't a case be brought against UNRWA? Well, UNRWA has immunity. There is an initiative now within the United States to seek to remove that immunity in the jurisdiction of the United States and allow, families of those who were murdered with the support of UNRWA as an institution, with their indoctrination and the fact that employees were involved and everything that they have done to support Hamas, because they have been complicit with Hamas and the 7th of October. And so we'll see what essentially the United States Congress does on the back of those requests. But the difficulty with respect to holding all UN institutions to account because of their vile hatred and their targeting of Jews is because of immunity. And vis-a-vis Hamas, well, international law works when you have law-abiding states that care about what court judgments might be issued against them. Hamas doesn't care. Iran, for that matter, also doesn't care. So when I mentioned that they rejoined the permanent jurisdiction of the court, they've done this to advance their own political agenda in the International Court of Justice and watch this space for what that actually looks like. Because the foremost state sponsor of terrorism in the world does not care about abiding by international law, and its proxies, Hamas, Hezbollah, likewise the Houthis, also do not care about international law. And it's a real failing, if you will, of the international legal system that it cannot cater for that. That's where politics comes into play. And that's where, a concerted effort to protect peace and security, which is what the United Nations was really established to do, which understandably sometimes involves the use of force. The coalition against ISIS, that was a given. ISIS is Hamas. And the fact that we do not have a similar international consensus on the need to defeat Hamas militarily is deeply, deeply worrying. What's the offense? There are lots of initiatives underway. The United States is the key focus for a lot of them, because the financial awards for things like, personal injury for victims of terror are substantially higher than anywhere else. And you also don't have cost shifting implications like you do here in the UK. But it's tricky because there are already substantial outstanding judgments against Iran. I think Syria also for on behalf of victims of terror. Go enforce them. And especially states that are under sanction in the United States, they theoretically don't have funds there to seize. So again, I think, unfortunately, the answer here is going to be political rather than legal. And we'll have to see what the next election brings in the United States. But that is about holding the key behind all of this, which is Iran, to account, and not reducing the sanctions, and not seeking to placate with a deal that allows them to achieve nuclear capability. But unfortunately, these are enormous battlegrounds, political battlegrounds, and it's very difficult to seek to use the law. When I use the term lawfare, I just want last sort of point just to clarify, I see lawfare as a real negative. It is an abuse of international law and an abuse of legal systems. But it is incredibly effective, which is why it is snowballed. Israel isn't in the business of abusing international law. It is a country that values law and order, the rule of law. That's why it attended this farce at the International Court of Justice. And so it won't be Israel supporting groups that seek to abuse international courts for similar purposes. And because of that, the options are extremely limited. But there are lots of processes underway, and some of them, in terms of anti-BDS initiatives, have been extremely successful. You may recall Airbnb's policy of discriminating against Jews living in Judea and Samaria. That was ultimately defeated because of a number of legal cases that were brought against Airbnb. The same thing essentially for Ben & Jerry's, which was settled. So there absolutely is a mechanism, and I haven't really spoken at all about UK Lawyers for Israel this evening, but one thing that UKLFI has been doing for well over a decade is using the law, applying the law, seeking its proper application to ensure that Israelis, Israel, Jews are not discriminated against, and in upholding the law proactively. It's not exactly offense, but it is proactive. There's been an awful lot that has been achieved over the last 10 years, and that UKLFI will still continue to achieve.
Which probably leads me to the question, is being a Zionist a protected characteristic now under the Equality Act?
On the basis that it's definitely been argued, but let's watch this space and see what happens with respect to Bristol.
Okay, more questions? Yes, please. Go on.
But yet, when the coalition forces fought against ISIS, nobody would want to ceasefire. And they are here this absurd demand that ceasefire Israel should stop defending itself. What is the response the state of Israel getting? Or were there any comparisons made about this hypocrisy?
So Israel's been clear that a ceasefire cannot happen without the return of the hostages. I think that much has been clear. And so the pause that we saw in November was as a result of an agreement to start releasing hostages. Now, that fell apart when Hamas broke the terms of that agreement, refused to continue to release the female hostages. And then actually I landed at Ben Gurion just as Hamas started firing again. And that was the end of that pause or ceasefire. But the concept of a ceasefire is a very interesting one. On the 6th of October, there was a ceasefire. And it was one that had been violated many times before. We've had previous operations in 2008, 2012, 2014, 2021. Although that involved, I think, Palestinian Islamic Jihad rather than Hamas. And then earlier, of course, in 2023, in the spring. And in each of these occasions, Israel has been prevailed upon to stop its defense. It has not been permitted to root out Hamas terror infrastructure. And the whole thing has worsened on the next occasion. I think the 7th of October was a watershed. No responsible Israeli government would be able to allow the threat that Hamas posed on the 7th of October to continue. And so in that sense, a ceasefire from Israel's perspective is out of the question, especially when 134 hostages remain being tortured, by all accounts, raped, starved within the Gaza Strip. But what does a ceasefire mean from Hamas's perspective? And this is something that is never, a ceasefire essentially means that Israel ceases and Hamas continues to fire. That is what we have seen on every previous occasion. And so in a way, ceasefire has now become this demand that Jews stop defending themselves and submit to Hamas terror. And that is unacceptable. And that needs to be called out. Whether it's coming from Lord Cameron, whether it's coming from the hopeful future Prime Minister, Keir Starmer, that needs to be called out, because leaving Hamas in place doesn't just mean a death sentence for further Israelis. It also means the continuation of the horror and the torture and the subjugation of the Palestinian people. And it's interesting that despite the threat that the Palestinian Authority, that Fatah and the PLO feel under from Hamas, because don't forget that when Hamas violently took over the Gaza Strip, they threw their opposition Fatah members off of the roofs of buildings in the Gaza Strip. And in the West Bank, Hamas is continuing to pose a threat to the Palestinian Authority. But publicly, they're saying they want a dialogue, they want a rapprochement, they want unity with Hamas. Well, what does that mean? Who are the potential partners on the other side of any future ceasefire or any future possible negotiations for some form of solution? Because the support for the 7th of October in the West Bank, Julian may know this better than I do because my memory is now failing me, but I think the last polls that we saw was something like 80%
Huge.
supported what happened.
I think there were comments that will do it again and again and again, but by leadership there. Any more questions? Yes, over there, please.
And what's becoming more overtaking various bodies of international law. As you kind of mentioned that there's actions to overturn various injustices like Ben Jerry's discriminating against works in GSMA. Is there any legal mechanisms that everyone can bring to the ICJ and the organisation as itself to essentially say, this has been a mistrial, a bit like how we simple, we can say there's a mistrial, that evidence has been properly examined. Is there any mechanisms that Israel can put forward to the organisation or the ICJ itself and say, this has been a complete farce, this whole case
Questions.
Either it needs to be examined or just completely thrown out?
Let me take a couple. Any more questions at all? Doing bunches. Yes, over there, please. I quite like being Fiona Bruce, but less biased. Let's take one more question. I want everyone to have a question. Over there, please. Over there. Thanks.
You're all welcome.
The orders made some question is how the orders are made in that case compared to other measurements in the base Singapore doesn't track that.
Okay, so summarising for the Zoom audience, mistrials in the ICJ first of all. Secondly, the issues about a two-state solution, the reality of it, and thirdly about the interim orders from the International Court of Justice. Again, 3 easy questions.
So Israel did what it could already, in a sense, in that when it attended the court for the preliminary hearing, it said this case should be removed from the list. That was, ultimately its shot at strikeout. And I think legally there was a very solid case for that, not least because it turned out that South Africa had utterly misrepresented the position of the communications between the parties before it actually made the application. And that came out in the oral submission.
Whether there was a dispute between the actual parties.
Whether there was a dispute and what opportunity had been afforded to Israel to engage with whether there was a dispute before it was brought to the court.
That was Professor Shaw's submission, I think, wasn't it? And it seemed to me the most powerful point there. Is there a dispute to engage the court's jurisdiction in the first place?
Absolutely.
What a surprise that the court decided there was.
Well, the court hasn't, the court has considered prima facie jurisdiction for the purposes of the provisional measures. And so all of that will continue to be under review when it comes to the substantive merits. I think, the odds of the court actually behaving like a court and acknowledging that this wasn't an appropriate case, it was without merit and it couldn't really advance, were always extremely slim, because undoubtedly there would have been international backlash, and that is all very political. And I think that's why you see, in a sense, it kind of splitting the baby and producing an order which it's an empty vessel, right? It can be anything to anyone, which is why I've even seen, members of our profession and lawyers commenting on this order, suggesting that that the court has found a plausible case that Israel's committed genocide. And I think that, if you read the order carefully, it's clear that that's not what the court says. But because there is so little substance, it's very easy to project these sound bites and these misrepresentations on it. So Israel's already essentially done that to no avail, arguably. Although the other thing that was interesting is that after the order was made, everyone was claiming victory because South Africa didn't achieve the one thing that it had set itself the prospect of doing, which was stopping Israel's operation in Gaza. And it was doing that at the behest of Hamas. It is acting essentially as Hamas's legal team. And Hamas celebrated the ruling and thanked South Africa for its efforts on its own behalf. But in that respect, what would have happened if the court had ordered Israel to stop its offensive in Gaza entirely? Israel wouldn't have been in a position to comply. Not when 134 hostages remain in the Gaza Strip, not when Hamas is continuing to fire rockets onto Israel. So that would have been a very, very interesting development. And it would also have been, I would argue, an unlawful order for the court to make, because the right of self-defense in international law isn't bestowed. It is inherent. It is recognized in Article 51 of the UN Charter as being inherent. No one can take that away from a country. So I think that would have been an unlawful order, and it's therefore not surprising that the court didn't go down that route. Two-state solution. There is no detail, certainly that I have seen. The lowest kind of granular level of detail that I recall in recent times ever seeing with respect to a proposed solution was in fact the Trump plan, where there was a very detailed economic plan to try and get a Palestinian society functioning properly. But so far as a two-state solution is concerned, there were very interesting hearings in the last week in Congress where I can't remember what her role was, but an official of the administration was put in front of members of Congress to answer questions on this. And one question that was being put to her is, okay, so who's going to lead this state of Palestine? Hamas? The Palestinian Authority, Palestinian Islamic Jihad? She didn't have an answer, and she refused to be drawn on the question. And so the question continued, well, has there been some thought to it? Maybe you can't give us the answer here, but you've considered the position, haven't you, as part of the policy that you're now putting forward of a two-state solution? Again, she refused to answer. So buzzwords that are incredibly dangerous and are having the opposite effect of the intended ideal of putting forward a peaceful solution initiative, and in fact having the effect of propagating the conflict even further. And that's why it's so dangerous, and that's why it's so damaging. And this idea, it sounds so positive. Who wouldn't be in favor of a two-state solution? Unless, of course, you're looking at a terror state run by Hamas, run by the Palestinian Authority with the backing of Iran. And that is unfortunately the reality which the buzzword doesn't grapple with.
The word salad in the order was the last question, about the order and what the wording of it and how odd it read, the order from the ICJ. You want to comment on that?
Yes. So I think certainly from what I have seen, it's the fluffier of provisional measures. There have been very much more targeted, direct provisional measures in cases in the past. In the Gambia case, in Russia, Ukraine. I mean, I think I mentioned that Sebutinde, the Ugandan judge, called out these provisional measures as being redundant. And in that respect, there's always going to be an element of, I think I actually heard a former International Court of Justice judge use this term, so I feel a bit better in adopting it myself. There's always going to be an element of fluffiness. And part of that comes from Julian's comment earlier about the different legal backgrounds that the justices are coming to these cases from, and different legal disciplines. Some of them, upholding rule of law, some of them less so. But even amongst those that come from countries steeped in rule of law, civil backgrounds, common law backgrounds, different approaches to evidence. And so inevitably, the cases at the International Court of Justice are going to be a bit of a salad, to borrow your term. And how they approach it has always been interesting. But that means that words like plausibility are never given a proper definition. And the discretion available to the court is extraordinarily broad, especially when it comes to provisional measures. It's a much, much higher standard when it comes to the substantive merits, which is why I think it's widely accepted in the international legal academic world that South Africa is not going to get home on its case because it's so egregiously meritless. But so far as the provisional measures are concerned, it's because of that broadness and that flexibility. And there are many who have been warning about this already from the Russia-Ukraine provisional measures hearings, where the court was seen by many to drop that threshold far lower even than in previous deliberations, that this is what was going to be coming for Israel in the not too distant future, and it's been proved correct. But this takes the biscuit in terms of the futileness and the sort of lack of there being any palpable sense of, whether Israel is required in any way to change its conduct, because its case has been that it complies with the Genocide Convention and therefore it just carries on.
Barak's dissent in that case was essentially autobiographical, wasn't it? It was him going through his life, the former Israeli Chief Justice, and having to tell the court that he's someone who does know about genocide in reality. In his dissent in that case,
there are elements of that separate opinion, and in fact not a dissent because he voted for two of the provisional measures that are very difficult to understand. Not least how he can claim, well, he can determine that there's no jurisdiction, which he was clear about, and then still sign on to two of the provisional measures because ultimately, and I paraphrase, they're probably a good thing to do. I mean, when a court of law having to follow specific tests and apply procedures decided that it was going to throw all of that out of the window and order something because it was a good thing to do, well, the International Court of Justice is set apart in that respect.
Let's take some more questions, two or three. Yes, please.
What's the concept?
That's right. At least we're going to do what, which is the start. Go on, what's the answer? Go on, carry on.
So people come up and engage Jews in conversation. They talk about a two-state solution. That's the two-state solution. It's reality of myself. But what's the answer?
Education. Education. And if you're talking to Jews, you might go to the Bible. Moses walked the Jews through the desert for 40 years when they left Egypt and came to the land of milk and honey. Why? It doesn't take 40 years to cross the desert. They stayed for a generation to change, because the Jews left Egypt a generation of slaves. And for them to be able to build a free country, in biblical terms, that generation needed to change, and the younger generation needed to be able to grow up and be educated in those values that they wanted that new society to embrace. And I said I would come back to UNRWA, and I'm so sorry I didn't, but it is at the center of everything for the last 75 years, since it was established in 1950. The purpose, the raison d'etre of UNRWA has been to perpetuate the 1948 War of Annihilation against Israel by creating a unique definition of refugee, only applies to the Palestinians, which is passed on generation to generation, to resettle them ultimately, and they don't say this in so many words, but ultimately when Israel is wiped off the map, to resettle these refugees. That's what the right of return ultimately comes down to. And UNRWA has been responsible for educating generations of Palestinians and indoctrinating them in the worst forms of hate and racism. You do not create 3,000 people who cross the border and commit the atrocities of the 7th of October overnight. You do so with 30 years of indoctrination. After the Oslo Accords, the Palestinian Authority-controlled curriculum taught in UNRWA schools, according to UN statistics, 3 out of 4 of the terrorists that crossed the border on the 7th of October were educated in the UNRWA school system. And none of this is new. Organizations like Impact SE have been reporting on the textbooks that are being used to promote martyrdom, to exalt the slaughter of Jews, and have been doing that for years. NGO Monitor has report after report out of the incitement to terrorism and the incentivization to terrorism under the pay-for-say scheme that we talked about before. UN Watch has put out countless reports about UNRWA's complicity in terrorism. And for the UN Secretary General now to turn around, and for Philippe Lazzarini, the head of UNRWA, to turn around and be also shocked about the recent revelations, I mean, it's unfathomable, because they've had report after report put in front of them making this case. And so the answer to your question has got to be education and denazification. And you start that process by abolishing UNRWA and by starting that education process from scratch, because otherwise you are setting up generation after generation of Palestinian children who are growing up to seek to perpetuate a genocidal war against Jews.
Let's take 2 more questions, and I'll give some concluding remarks. One from Michael. We'll do a bunch of 3. 1, 2, 3. Yeah. So remember, go on.
To save your voice.
We've got 2 more questions. Yeah, you ask your question, Michael. Go on.
When I was in Israel, it was quite a few months before the demonstration was on the street for another government trying to override the Supreme Court. You think that's history now?
I want to take a couple more questions so we answer that. There were a couple more hands up, I think. Yes, over there, please. So I want to take all the questions now, then we're going to finish up. Yes, sir.
You touched on the 2-state solution. Has anything been done to educate the lives of one child? The words fail. You know what I mean. And to educate them about how wrong this is, and to put the consequences of it to them.
All right, and then any more questions over there, Michael? Yeah, over there, please. Yeah, thanks. And then I think that's a wrap. We'll call it for questions. Then Natasha will answer, and I'll ask the Zoom to be turned off. So can we educate Lord Cameron? And what bodies can we put pressure on? And then there's Michael's question as well.
In terms of the bodies to put pressure on, you all have members of parliament. They are inundated with anti-Israel correspondence and put a lot of pressure on. And they'll take what their constituents say into account, and many of them will feel educated by what it is that they receive in correspondence. So it may sound trite, but writing to your member of parliament, seeking to engage with them. This is something actually that APAC, for example, does extremely well in the United States, is get its members to engage with their representatives in Congress and educate them and call them out and keep them to account. And we can definitely be doing an awful lot more here with that. I mean, there are organizations like Conservative Friends of Israel, Labour Friends of Israel, We Believe in Israel, that often does letter writing campaigns along that process. The Zionist Federation, which is no longer really with us, the National Union, the Jewish National Assembly is seeking, I think, to take up the lobby day that the ZF used to run. So there are all sorts of opportunities to be proactive. I know it takes time and energy, but I have to say, from my perspective, having been doing this probably about 20 years now, it's so rewarding. I feel blessed that I'm able to, serve a cause higher than myself. And I would that all of you have a similar experience of being able to achieve and educate and have palpable results. And one of the ways is engaging with your local representatives. We talked about complaints to the BBC earlier, writing to the newspapers or op-eds. I mean, there are so many ways in which, once you understand what the issues are and how to tackle them and the resources available for that, I advocate enormously the UK Lawyers for Israel website, where we've got lots of briefing materials on the legal aspects, because international law is consistently misstated on this subject. But there's also, for those of you who know students, Stand With Us, Camera provide an awful lot of resources online. And I know that a few of you have already mentioned social media. That's a massive battle. And if you feel able to engage in that war of attrition, then good luck to you. You're stronger than me. But there are so many different ways and organizations that you can get involved with. And any lawyers out there or non-lawyers who are interested in being on the UKLFI mailing list, please email info@uklfi.com and we'll sort that out for you. So far as educating specifically on a two-state solution is concerned, well, I am available for Foreign Office briefings and weddings and bar mitzvahs. And we try as much as we can. I mean, one of the wonderful things about UK Lawyers for Israel and the patrons that see fit to support us, some of the top lawyers and judges in the United Kingdom, hugely well-respected individuals that support what it is that we say and give our submissions weight. And occasionally that really, hits home. And we have had an awful lot of previous success. There's a big tide to work against. And we are continuing to make the legal case and put that in writing and try and ensure, if they're willing to read them, the briefing materials are there. So that is definitely something that we're pursuing. And then this is an interesting point to end on, because it is one that, but for the 7th of October, I may very well have been sitting in front of you talking about exactly what it was that was consuming Israeli society in terms of the legal reforms. I don't think that issue is history. I think the reason it cannot be history is because there is a deep rooted problem within, no country is perfect, but there is a real imbalance, unfortunately, within the Israeli separation of powers and the democratic system, where over a very long period of time, starting in the 90s, and also under Aaron Barak, who we mentioned previously, was Israel's ad hoc judge at the ICJ, a substantial portion of the electorate in Israel see the Supreme Court as having massively overreached and left the world of legal questions and inserted itself into the world of politics. And after the last election, albeit that before there was a broad political consensus that legal reform was really necessary, and Lapid and Gantz, the leaders of the opposition before the war, were calling for legal reforms, after the last election, things took a really nasty turn. And the divisions were unlike anything Israel had seen. And the political campaigns, in particular against Netanyahu, that created a narrative around the reforms which hadn't existed before, were really painful to watch. And it was, the Rak Lo Bibi, anyone but Netanyahu campaign that got subsumed into the question of legal reforms. And the reason that they were originally proposed was because of what was seen as a democratic deficit. An unelected court having the possibility of interfering in political questions, which should be the preserve of the democratically elected parliament and government. And then that was being turned on its head, and the suggestion was that actually democracy was under threat, and both sides were seeking to present themselves as the champions of democracy. That hasn't gone away. I've been in Israel twice now since the 7th of October, and the unity is remarkable, and the resilience is inspiring. And that, please God, will continue even after Hamas is defeated. But these critical questions that go to the core of, Israel's constitutional makeup have to be answered at some point. I hope the distance, as we get further from the 6th of October, from that really dark time, will provide a perspective where they can be assessed in a fresh light. But there are certain things that I've seen even now developing, organizations, movements that indicate to me that prospect of dealing with the constitutional reform package and changes in a grown-up, mature fashion that would make other democracies proud of engaging in a rigorous debate and proposing amendments and debating them. There are certain movements even now that indicate that may not be possible. So perhaps it's hope over experience. The issue will definitely come back. Israel was weakened by those divisions, and its enemies took advantage of that. And that is an abiding lesson. And if we collectively, the Jewish people, the state of Israel, can learn from the horror of the last few months, is that we should never allow ourselves to be so divided again.
Under Rule 15, paragraph 625A of the Israel Society Constitution, and bringing this meeting to an end, we have had an absolute tour de force from Natasha, who is the most fantastic advocate for the Jewish people, for Israel, for democracy, for justice, and for common humanity and decency. She's been absolutely fantastic. Really, really brilliant. Really brilliant. Few things that I want to say. Firstly, if you are a lawyer, a law student, or a jurist, or just interested, please go on the UK LFI website and join UK Lawyers for Israel. That's the first thing. Secondly, please, if you want to support her work, please donate to the UK LFI Charitable Trust. You can go on the website and find out about them. Please do that, because this is really, really demanding work that she does. And we've seen her on the news, the web, the BBC, all the papers and so on. Please do that. Thirdly, there's a donation bowl, so please feel free to donate if you feel able to after this talk. I want to thank a few people for this fantastic evening. Michael and Judith and Liat for helping to arrange it. I hope we can leave here well informed and knowing that I think the analogy that I give is that we're unfortunately in a world where, those tennis machines that whack out those tennis balls, and you've got to keep on hitting each one, basically. Each one and that's what we've got to keep on. That's what we've got to keep on doing. We're assailed politically, militarily, in the legal sphere as well. And it's an extremely, it's a very frightening time. But there's also, with advocates like Natasha, there is also, great hope as well, Hatikva, too. So thank you again, Natasha. Thank you. I think Michael wants to say a few words.
Well, you've taken the words out of my mouth, clearly.
Concluding remarks.
I was really going to say how fortunate Israel and we, as the Jewish people, have somebody like Natasha as an advocate who can speak up so eloquently on our behalf. So, and thank you very much for taking the trouble on a Sunday night to come along. This is the second time that we've had Natasha, actually. The first time on Zoom, the second time live, as you can see, and I hope in due course we'll be able to ask you again when the horrible state of affairs is over and we can look to the future. Now, we've got tea and coffee outside. Please stay and have something with us. And Natasha hopefully will join us. You can talk to her.
Under Rule 74.8, you must stay for tea and coffee.
Yep, yep.
Paragraph A.
Say, as from the rabbi,